back with professional conduct, and like the way they say that iron sharpen iron, so I believe that we are getting ready for the exam. So basically, when you're getting ready for the professional conduct exam, it's important to know who is an advocate. And section 1 of the Advocates Act defines an advocate to mean any person whose name is duly entered on the roll of advocates, whereas a client is defined to mean any person who has instructed or is about to instruct a client. So that means that your client is not necessarily the one who has paid you, but any other person who has potential, or maybe who you are supposed to recover costs from. So that person is also deemed to be your client. So when you look at the Law Council, Section 2 of the Advocates Act establishes the Law Council, and the functions are in Section 3, which says to exercise through the medium of the Committee on Legal Education and Training, general supervision and control over professional legal education in Uganda, and also to advise and make recommendations to the government on matters relating to professional of advocates. So you have to read Section 2, which establishes the Law Council, as well as Section 3, which gives function of the Law Council. And then taking of instructions, you have to understand that Article 28, subsection 2D of the Constitution provides every person is entitled to a lawyer of his or her choice, especially in criminal proceedings. But also when you read Regulation 2, Subregulations 1 of the Advocates Professional Conduct Regulations, states that an advocate cannot act of any person unless they have received instructions. And then Regulations 2, Subregulations 2, an advocate shall not unreasonably delay the carrying out of instructions received from his or her client. And we have the case of Mulenga Christopher vs. Stanbic Bank, which reinforces that an advocate must have instructions before acting, and that these instructions are essential for an advocate to represent a client. Then also retainer, the relationship between an advocate and a client is often referred to as a retainer, which involves the instructions given by a client to an advocate, or a fee paid to the advocate to act on a specific matter. So most of the law firms are on retainer. I find that a bank like the FCU or maybe Stanbic pays a law firm at a monthly basis, so as it can keep on giving it advice. So we have the case of Omorere and Toro Advocates versus Magum Properties Limited, which clarify that a retainer need not be written and can be inferred from the party's conduct of circumstances. So basically, a retainer is where the firm has agreed to pay you on a monthly basis, so as you act in its own interest. So commencement of advocates earning. So in Myers and another versus Hamilton, it was said that an advocate is entitled to an instruction fee when they are entitled to sue or defend on behalf of a client. And we see that effective filing proceedings without instructions, in the case of Kabare Housing Tenants Association Limited versus Kabare Municipal Council, the court ruled that an application filed by council without instructions was incompetent. So you have to make sure that when you are going to file pleadings, you have properly received instructions. And when we talk about instructions, we mean that you have been paid. And also be aware of the regulations which says you cannot charge below the advocate's fees or above. So you are obliged to charge the amount which is in the advocate's remuneration of fees and costs. So withdraw instructions, conflicts of interest, and confidentiality. So withdraw from instructions of a client's case. So every client or advocate have powers to do what? To terminate the relationship. And the grounds are under Regulation 3, Subregulations 1, that an advocate may withdraw from a case if the client withdraws instructions, or the client instructs the advocate to take any action that may involve the advocate or professional misconduct, or to act contrary to his or her advice. And the advocate is permitted by the court to withdraw, or the client fails to pay fees or disbursement. So under Regulation 3, Subregulations 1 of the Advocates Regulations, it gives you circumstances under which either a client or an advocate can withdraw a matter. And the procedure for withdrawing under Regulation 3, Subregulations 2. So whenever an advocate needs to withdraw from the case, the advocate shall: 1. The advocate must notify the client, the court, and the opposing party of the intent to withdraw, and the advocate must refund any unearned fees to the client. So you must give a notice, but also if the client had paid you 50 million and you have so far used 5, then the law requires you to return the remaining 15. So duty flowing from withdrawing. So upon withdrawal, the advocates must return any documents or property in their possession, provided the client with necessary information and account for the funds. Then conflicts of interest. Basically, we're not supposed to act for the client if he has been your former client. What do I mean? For example, if you are suing X and you were a counsel for X at one time, then there is a conflict of interest. And this one is provided for in Regulation 4, which provides that an advocate shall not accept instructions from any person if the matter involves a former client. And we have the case of Sidiri Praria versus NMAX advocates. The Bank of Uganda had instructed NMAX advocates and Sudil Suruke Kampala Associated Advocates objected that these were his former lawyers, so there was a conflict of interest, and of course the court agreed with them, and they said that NMAX should not represent the Bank of Uganda because it has a lot of information to deal with Sudil since they had a business relationship. They also have a duty of confidentiality. An advocate has a duty to keep all information obtained from client confidential as part of the fiduciary relationship. And we can see Regulation 7 of the Advocates Regulations, which prohibits the disclosure of client information unless necessary for the case or required by law. And we have the case of Sauswala and Voxball case, which emphasizes that the importance of maintaining client confidentiality, stating that removing confidentiality should not outweigh the potential risks of injustice or society harm. Then the Evidence Act, basically Cap 8, which outlines the rules of confidentiality in Uganda, and Section 125 of the Evidence Act specifically restricts the disclosure of confidential communication between a client and their advocate unless waived by the client or under certain exceptions. So that means you cannot be forced to disclose the communication that transpired between the advocate and the client. So Section 126 of the Evidence Act extends the privilege to the advocate's staff, like the clerks. Section 128 of the Evidence Act limits forced disclosure in court the confidential information between the client and a legal professional advisor. And we have the case of course, Ara versus King, where it was stated that legal professional privileges applies to confidential communications but does not extend expert opinions or documents relied upon for such opinions. We also have the case of Peter Jango, MC Ayume Tabo and Company Advocates versus Registered Trustees of the Church of the Province of Uganda. This case clarifies the conditions under which the advocate-client privilege applies. So, duties of an advocate, of course, we have duty to appear in court under Regulations 5, Subregulation 1, which provides that in all contentious matters shall either appear in court, personal or brief partner or a professional assistant to appear on behalf of him or her. So, under Regulations 5, Subregulations 1, you are supposed to appear in court on behalf of your client. And Regulation 5, Subregulations 2 provides where subsection 1 above is not possible, he or she shall brief another advocate accepted by the client so as to appear, except where that proceeding is a minor client minor, client consent will not be required. So under subregulations 1, the regulations are saying that you are supposed to appear for your client in contentious matters. Then under subregulations 2, you can instruct another advocate if the matter is too contentious or it is very fundamental. You need the consent of the client, but where it's not, you don't need the consent of the client. Then advocates to personally be responsible for client's work, and we see Regulation 6, which provides that an advocate shall personally be responsible for client's work and shall make arrangements for supervision of all work undertaken by non-professional employees. So basically, if you are in a law firm and you make a mistake, they can't blame you, they blame the advocate, because under Regulation 6, they are supposed to be personally responsible for the client's work. Then we also have advocate account for money of a client, and basically this one we look at Regulations 8, Subregulations 1, which provide that an advocate shall not use money held on behalf of a client either for the benefit of himself or herself. So we are aware that law firms have what we call the client's account, where all the money for the clients is always deposited. So you are not supposed to use this money You get, you're not supposed to use this money for your personal benefit. So regulations 8 subregulations 2 provide that an advocate shall make full disclosure to his or her client of the amounts and nature of all payments made to the advocate on behalf of the client. And we have the case of Muema versus Shell, where the court said that advocates cannot work on continuous fees or share the proceeds of the litigation. Then we have what we call fiduciary duty, which is in regulations 10, which provides that an advocate shall not use his or her fiduciary relationship with his client for personal advantage. So basically, you shouldn't use the information you have for the client for your personal advantage. And when you look at Regulation 11, provides that an advocate shall not exploit the inexperience or lack of understanding of the client. Then duty to advise clients diligently. Regulations 12 provides that every advocate shall advise his or her clients in their best interests, and no advocate shall recklessly encourage a client to oppose or continue any litigation which a reasonable advocate would not. So under Regulations 12, you have to advise your clients diligently. So basically, those are some of the duties of an advocate which you must pay attention to in your preparation for your exam. Then duty to court. Duty to court, affidavits contain the truth. So Regulations 15 provide that an advocate shall not include in an affidavit any matter which he or she knows or he has reasons to believe is false. And advocates inform the court of his or her client false evidence. So Regulation 16 provided that if any advocates become aware that any person had sworn a false affidavit or given false evidence, he or she will inform a court. So you see, the affidavit must have the truth under Regulation 15, and if you are aware that someone is relying on false evidence, you have to bring it to the attention of court under Regulation 16. So the duty of an advocate to advise the court on matters within his or her special knowledge. So Regulation 7 provides that an advocate conducting a matter shall not allow a court to be misled by remaining silent about a matter within his or her knowledge. So under Regulation 7, where you believe that the court is being misguided, you ought to direct it to the law. Then coaching of clients, most especially witnesses, you shouldn't tell them what to reply. So Regulations 18 provides that an advocate shall not coach a person to give evidence or allow any person to give evidence when he or she knows the person has been coached. So this applies in witnesses. You shouldn't tell your witnesses the answers. You can prepare them, but not coach them. Advocates not hinder witnesses. And Regulation 19 provided that an advocate shall not, in order to benefit his or her client's case, in any way intimidate a witness who is to be called by another party. Then Regulations 20 provides what we call the res sub judice rule, and we have already heard about the res sub judice rule, which restricts advocates to talk about matters which are before court in national media. And Regulations 20 provides for the res sub judice rule, which provides that an advocate shall not make announcements or comments to newspaper or any other news media, including radio and TV, concerning any matter pending litigation in which he or she is or not involved. So that's the sub judice rule under Regulations 20. So we have the cases here. There is the case of Sarimans versus Nilo Bank. Advocates must not impose unfair conditions or unfair delay proceedings, such as refusing to grant adjournments without valid reasons. So basically they are saying that advocates must not impose unfair conditions or unfair delay proceedings, such as refusing to grant adjournments without valid reasons, or maybe asking for adjournments when you don't have a valid reason. So basically that was it for the duties of court. Also you have professional correspondence, which means you have to have a duty to another counsel to, of course, serve them, as well as ensure punctuality in fulfilling your obligations, and promptly respond to professional letters requiring an answer. So you should make sure that you properly communicate with the other advocate. Then undertakings, Regulations 14, avoid giving or requesting undertakings that cannot be fulfilled. Honor all undertakings and trust conditions once accepted. Draft undertakings in clear and unambiguous terms, and failure to fulfill an undertaking constitutes professional misconduct. So basically, Regulation 14 says you shouldn't undertake a work you know that you cannot do. So if you know that, for example, you are not fit to go into the Supreme Court, then you shouldn't accept the client who has a matter in the Supreme Court. Then also have representations and negotiations. You must act in the interest of your client, avoid criticisms of other advocates, and respect lay persons roughly representing themselves. We also looked at conflict of interest, and the standard of conflict of interest was explained in Uganda versus Patrick Ojangore, and they called it, the standard is what a reasonable person expects. So what can a reasonable person do in the circumstances? Then professional misconduct, it includes acts of dishonor, disgrace, or improper conduct that bring the profession into dispute. Examples include misappropriation of current funds, giving improper advice, misleading courts, or suggesting or engaging in bribery or corruption. Judicial standards, we have the case of a solicitor ex parte the Royal Society 1912. Misconduct involves intentional wrongdoing or behavior contrary to the professional norms. So key points are lack of instructions in Kabari Housing Tenants Associations Limited versus Kabari Municipal Council. Filing without instructions also can constitute a professional misconduct. Then lack of proper due diligence. We have the case of David Sejaka Nalima, I think, versus Labeka Musoke. David Sejaka versus Labeka Musoke. So because in that case, what happened that the lawyer had not properly done due diligence, and the client could not be said to be a bona fide purchaser of value without notice. So he found an old woman on the land, and fraud was imputed on the client. So you have to do proper due diligence. So professional negligence, defined as failing to render services with reasonable skill, prudence, and diligence. So you must make sure that you provide services which a reasonable advocate is expected to provide. And have the case of Joseph Kaoya versus Uganda. Defense counsel's casual handling of a criminal trial resulted in inadequate representation, breaching ESCO and professional standards. So this was the case of Joseph Kaoya versus Uganda, whereby the advocate acted negligently. So of course we have looked at summary of key points of professional negligence and misconduct, and the way we looked above. So we looked at professional undertaking in the case of regulations 14 of the advocates regulations that you shouldn't undertake a work you know in your means you cannot do. And we have the case of Equip Agencies Limited versus Credit Bank Limited. Breach of undertaking is both professional and potentially criminal misconduct. We also have Section 18, subsection 1 of the Advocates Act, provided that the law counsel may subject to a person obtaining a special practicing certificate admit to practice as an advocate for purposes of a matter of any legal practitioner in a Commonwealth country. So basically, if you have watched the proceedings in the BCJ case, where we have a Kenyan lawyer who is the head of bar of Kenya, so for you to come and practice in Uganda, you have to get this what we call special license from the Chief Justice, and then you proceed to apply the law counsel under Section 18, subsection 1 of the Advocates Act. So Section 46 of the Advocates Act provided that every advocate shall, in connection with or her practice as an advocate, keep accounts in compliance with the Advocates Accounts rules and the Advocates Practice Accounts rules. So you must have a client's account and a personal account under Section 46 of the Advocates Act. Then Section 33 of the Advocates Act provides that banks shall not inquire into the dealings with the client's account. So these client's accounts are always protected. Then we have disciplinary powers of courts. Courts retain inherent jurisdiction to address advocate misconduct, and we have the case of Shell and 9 others versus Mwema. Then also have sharing fees and champati agreements, and the advocates cannot share fees with non-lawyers or base fees solely on a case out of champati agreements. So basically, champati agreement is any agreement that entitles you to share the benefits of of the judgment. And we have the case of Fred Muema, because Fred Muema was representing the share these fuel companies, because the URA had overtaxed them, but then he had signed with one company, Rock, be paid I think 15% of the judgment. And luckily for him, Fred Muema won. Then he tried to request for this 15%, and the court said that this was a champati agreement, because it was entitling him to share on the proceedings of the judgment, but also it was not notarized like the way it's required under the law, under section 57. Yes, you can do agreements with clients under section 54 and 56 of the Advocates Act, but they must be notarized under section 57 of the Advocates Act. The agreement shall contain a certificate signed by a notary public. So you find that most of the lawyers always have these agreements, but they don't have a certificate from the notary public, and most of them are always struck down. And we can see the case of Chutuma Magara and Company Advocates versus Celtic Uganda Limited. Remuneration agreements must comply with necessary requirements to be enforceable. So they had also notarized it. So we also have provisions on holding out. Holding out is where you appear before court or you purport to act for the client as if you have instructions. So section 7 of the Advocates Act, a person not act as an advocate who is not qualified as one, he or she commits an offense. And section 71 provides that an unqualified person not hold himself or herself out as qualified. So if you are holding out, then they can penalize you under section 70 of the Advocates Act and section 71. Then conclusion on professional standards. So basically that was it for that brief highlight into holding out. Basically section 70 and 71, we looked at champati agreements, section 54 and 56 of the Advocates Act, and also section 57. We looked at section 18, which provides for obtaining a special certificate of practicing certificate. We looked at section 46, which provides for what we call client's account, and section 33 protects this client's account. We also came here up and looked the case of Kabari Housing Tenants Association Limited versus Kabari Municipal Council, which says that filing without instructions is an ESCO issue. And we see the case of Uganda versus Patricia Ojangari says that the standard in conflict of interest cases is that one of a reasonable person. We also looked at the case of course, Deal versus NMAX, basically on the conflict of interest. And we looked at, of course, the sub judice rule in Resolutions 20, and we looked at not coaching witnesses in Resolutions 18. We looked at affidavits to contain the truth in Resolutions 15. We looked at fiduciary duty in Resolutions 10. We looked at advocates account for money of the client in Resolutions 8. We looked at advocates person be responsible for client's work in Resolutions 6. So basically, and also the duty of confidentiality in Resolutions 7. So those are one of the regulations you must make sure that you understand before going to the exam next week. So then I wanted us to, of course, discuss these additional cases because they can be important. So we have the case of Shell versus Fred Muema and Company Advocates. The parents challenged elimination agreement between Rock Petroleum Uganda Limited and its advocates. The first respondent entitling the advocate 16% of the claim of the proceeds and an additional 4% if recovery involved appeals. So the agreement was entered into by Rock Petroleum alone without the knowledge of other appellants. So the advocate sought to enforce the agreement against all the appellants, leading to various court applications. So the issues was one, whether the regard of the remuneration agreement under the Advocates Act and principles of public policy, that is champati agreements, then the obligations and conduct of advocates when representing multiple clients or former clients. So it was held that under Section 54 and 56 and also 57 of the Advocates Act revised. These were champ-party agreements, and they were not authorized, so the lawyer could not benefit from them. And advocates must avoid conflicts of interest and protect client confidentiality. We also have the case of Exhale High School versus John Paul Wengana. The court emphasized that advocates cannot represent a party against a former client if it prejudices the former client or involves confidential information. So basically, this one should be read together with Sudil versus N Max, and also we have a lot of other cases which basically speaks to this effect. So advertising and conduct, advocates are restricted in advertising their services under Regulations 25. So as a lawyer, you're not supposed to advertise under Regulations 25. So professional misconduct includes misleading clients, accepting instructions via unauthorized agents, and engaging in contempt of court. So basically, when you look at Regulations 25, basically you are not supposed to advertise as a lawyer, and they give you that this, even if you put a signpost on your law firm, it must be very small. It shouldn't be very big. So basically, the proof what we have looked at, we looked at Section 1 of the Advocates Act, which basically defines an advocate as any person whose names is duly entered on the roll of advocates. And when you look at Section 8, Section 12 of the Advocates Act provides that the register shall keep in accordance with this act a roll of advocates, and Section 13 gives you how admissions and how they can admit and enroll of advocate. So basically, under Section 13, you must be from a recognized university, have finished LLDC, then you attach your documents and apply to the law council. Then the law council gives you what we call a certificate of eligibility, which you do what? Which you take to the newspapers, and then after that you have been gazetted. What they do is they enter you on the roll. So basically, you read Section 13 of the Advocates Act. It gives you admission and enrollment of advocates, and that's how basically you apply for law council with the necessary academic documents. They give you a certificate of eligibility, which you take to the gazette. You pay 300 to be gazetted. Then after that, you return it back. Then after that, returning it back, they now call you to do what? For enrollment and become an advocate of the High Court. Then also look at issue of practicing certificate and the right to practice under Section 16 of the Advocates Act, that for you to practice in Uganda, you must have what we call a valid practicing license certificate, which is renewed in every year. And we also looked at Section, basically we looked at Section 17 gives a refusal of practicing certificate, where you are bankrupt, where you have a mental problem. Then they can do what? They can refuse you to give you what we call the practicing certificate under Section 16. Then we also looked at Section 18, which provides for temporary admission, where you can apply the law council when you have a special practicing certificate like this Kenyan lady. Then from there, it's also important to look at the establishment of the disciplinary committee under Section 25, and basically under Section 25. Then Section 26 provides for pro bono legal services, that every advocate shall provide pro bono services when required by the law council, or pay a fee prescribed by the regulations where you have not provided those legal pro bono legal services. So pro bono legal services basically means free legal services. So let us look at Section 27, which provides for complaints against advocates. So where you have a complaint against the advocate, you can lodge it with the disciplinary committee under Section 27, and the disciplinary committee basically it serves summons to the advocate, who then is required to appear before it, and then puts his case before the committee, and we see that the committee have powers to remove him on the roll, suspend him, order for any payment to this person under section 27 subsection 5. So then he also have a right to appeal. He also has a right to appeal under section 27 subsection 12, and he can appeal the decision he can appeal the decision to the High Court under section 28. So under section 20 what? Under section 29, you can appeal them to the High Court. But also you have to look at section 25 subsection 8, which provides that where a solo practitioner has been suspended from practice or struck off the law, the Law Council may order the closure of the practitioner's chambers and shall appoint a trustee to take care of the interests of the practitioner's clients and the pending matters of the practitioner. So where you have a solo law firm, you are the only advocate, and you have been found guilty of professional misconduct and have been struck off, the disciplinary committee appoints a trustee who is an advocate to take care of your clients. So basically that was it for professional conduct. I believe this gives you a guide to approach your exams. I really wish you success. I am very sure you can do this. Please expound on this summary, and then professional conduct is going to be one of your easiest tests. Please have a blessed day, but please subscribe, like, and comment.